Hey guys, it's Karalynn and welcome back to the podcast. As you may know, I'm a construction attorney and I have been so for 20 years. And I'm the owner of the Karalynn law firm that has been in existence for 20 years as well. And a big part of our business is lien and collections. And then what happens after you file a lien. So today I'm joined by my head of lien and collections, who has been for over the last 15 years. And we're going to talk about like what happens after you file a lien, what are the options, what is, enforcing the lien look like, what, if you don't get paid before the lien is filed, what can you do? It's good to have you on the show, Jess.
Thanks for having me back.
All right. So you head up lien and collections. How often do our clients end up having to enforce their lien?
Well, our collections are good, so I'd say about 30% of the time.
Gotcha.
Not getting paid on a job you already completed? Well, that's where we come in. At the Karalynn law firm, our lien and collection department helps you get paid fast and the right way. You did the work, you deserve to get paid. We help you take the right legal steps by filing liens and collecting the money that's owed. Contact us at 713-715-7334, or you can visit our website at www.thekrominslawfirm.com.
All right, so filing a lien for construction is a very powerful tool. But what would you say would be the next step? Like, how do they enforce their liens?
Okay, so there is a couple of options, right? And it kind of depends. So it really depends on the type of project. So if we're in something that is brand new construction, right, and there's a bank involved, which has got bank finance, normally when that happens, they're in construction financing. And so once the project is done, they'll have to go to permanent financing. And before somebody can go to permanent financing, all of the liens have to be taken care of. So if we file the lien and it's, for relatively, between under $50,000, but it's new construction and we've looked and we know that there's a construction loan, I would probably say wait until permanent financing, right? Because they're going to have to pick up all the liens. Now, deadlines might get involved there that might trigger you to move forward, but it also depends too. Has anybody said anything? Has anybody, has there been any response to all of our letters, all of our phone calls? Are they promising to pay you? What does that look like, right? So the first thing is that if it's new construction going to permanent financing, we'll probably wait. Or, if the property is going to sell sometime soon, if like it's a new home, they know they have a buyer and it's going to flip, then we'll probably wait.
So what does it actually mean to have a lien on a property?
So a lien is a security interest in the property that you provided labor and materials to, right? So generally speaking, most debts in the world are unsecured. So think about like if you have a credit card with Home Depot, you run up a bunch of charges, you don't pay them, they got to sue you, and then they got to find assets to collect their debt. So that's an unsecured debt, right? And a secured debt is more like a mortgage. So you go and you want to buy a house, you go to the bank and you borrow the money and the bank takes back a security interest on the property. And if you don't pay them, they sell the property to get the money that they're owed. That's a secured debt. And so contractors are very fortunate. They're one of the very few industries that can have a secured debt, basically involuntary, right? Nobody's agreeing to let you have a lien. And so if you follow the proper steps and you have a lien, you now have a security interest, which is just as enforceable as a mortgage against the property that you're owed, right? Without a lien, a contractor still has remedies. Basically, it's suing out a breach of contract of the contractor or the owner that hired them, but it's not secured, right? They got to file a lawsuit on the breach of contract, they got to win a judgment, and then they have to find assets. So a lien is so huge, and contractors are fortunate to have it. It's a very strong remedy. But back to the first question you asked me. So we went over kind of the options if a project's going to financing or going to sell, but what if it's not, right? Like, so one of the big things we have is apartment complexes. How many apartment complexes that are existing pay?
0.
So like if you're working on an apartment complex that's existing, that's not going to sell anytime soon, like, rehabbing after people move out and people move in or any kind of work, those will ultimately, if you want to get paid, you'll have to sue to enforce the lien, right? Because they're not in any, they're not going to sell. They don't care if you have a lien. It'll just sit there till it expires. So there are some projects like that the only option is to file suit to enforce the lien.
So the number one question that we get, can we refile the lien or renew the lien, or does it actually expire?
So you cannot renew the lien. It does expire. And in Texas, it's 1 year. Some other states might be as short as 90 days or 6 months. And so, like, what does that mean? My lien's going to expire. So your lien's still there, but it wouldn't be enforceable, right? In order to preserve your lien rights, you have to file suit to enforce the lien within that year timeline, right? And so that means filing a lawsuit against the owner to foreclose the lien, right? The actual remedy, the ultimate remedy, is forcing the sale of the property to satisfy the amount that you're owed, just like a bank, right? Except in 99% of the cases, that does not happen. You get paid way before you sell the property, but that is the end result.
So why suing the owner and not the GC?
Or whoever hired you. And you could sue both, right? Okay, so a couple different things. If you're a sub that is hired by a general contractor who was hired by the owner, you can file your lawsuit to enforce the lien and sue the general contractor for breach of contract. That way you have two parties. If you're a material supplier, right, who sold to a sub, what you could do is you could sue the sub that you supplied the materials to under breach of contract and then sue the owner to enforce the lien. Now, generally speaking, the lien claim is a stronger claim because it's, did I follow the timelines? Did I timely follow my lien? And if I'm just fighting the property owner, those are the only things I have to prove. Also, the general contractor is required by law to indemnify the owner. So if the owner gets sued, guess who they're going to call screaming to take care of this lien in this lawsuit, which is great leverage on our side because the GC has to indemnify the owner.
So there is a hard deadline.
Correct.
To enforce your lien.
Correct. And and here's the thing is that the lien's not going anywhere. It'll still be there. And what normally happens, even though after it's expired, if a property sells or something like that, a title company is just not going to go, oh, the lien's expired by law. They're either going to want to release or court order removing the lien. So we get calls all the time from title companies from liens that have actually expired. And usually we can get the client something, right?
I got one the other day,
yeah.
like 10 years old.
And
I was like, okay. Hey.
And so sometimes even if it's expired, if it comes up on a sale, you could still get paid. I would not rely on that because the other option is they could sue you to remove the lien and then they could get their attorney's fees for having to sue you. So, legally it's expired. In actual practice, you might get paid something after it expires.
So what should someone do to not miss that window?
So, after you file the lien, calendar the deadline, right? We'll follow up with you if you file a lien with us and say, every month, like, hey, your lien's going to expire this month. You need to take action. And it's really up to you whether you want to let the lien expire and not enforce it or move to enforce it, right? Because after the lien expires, I'm not going to file suit to enforce it because I know it's no good, right? I might reach out to the other side and try to get you some money for a release, but it's really, I'm not going to file a lawsuit because the first thing that they're going to say is your lien expired, and they would be right.
Okay, so let's talk about costs, because sometimes that is their number one, what's it going to cost me, or should I actually file a lawsuit to foreclose on this lien because it's only $15,000?
And that's a real consideration, right? Because there's no quick remedy. You don't just file the lien and get paid. Sometimes you do, right? And it's great when that happens, but other times you don't. And so let's talk about what the options look like, right? So normally there's not any that I know of construction lawyers that would take lien cases on contingency fee. It just doesn't happen. So that means you're going to have to come out of pocket something. And that's not to say like under the lien statute in Texas and in most states, you are entitled to get your fees back, right, of what you pay. Now, what you actually get from the court would probably not be what you pay. That's just what happens in actual court and all of that. So you're going to settle for something less. So, how we do litigation, how we've done litigation for the full 20 years is we have a general retainer. It's $2,500 to get started. That goes to our trust account. We don't use it. And then we bill every 2 weeks. And you're looking at an attorney rate from $350 to $450, a paralegal from $150 to $250. and just the hours that it would take. And sometimes it's a lot of hours and sometimes it's not, right? Sometimes like to get a petition filed, to get the other side served, you're probably looking at a minimum of $5 or $6 grand, easy, to do the petition, to file the list pendants, to get the citation, to get them served, right? It's not just something that is done relatively easy, right? And that's an hourly fee. And so what we figured out over the last 20 years is we figured out a better way to do things. Right. So we've started offering, at least for our clients in Texas currently, subscription litigation. And what does that mean? That means regardless of how many hours an attorney spends on the file, you will pay the same amount every month. Right. And so we start at $3,000 a month. And that's usually for our cases that are under 50 grand on our lien foreclosures. Right. And it's got a 3-month minimum. So you're going to pay at least, $9,000 for the subscription. But I mean, if you're owed 50 grand and you pay $9 to get it, and in that negotiation, you might be able to get some of that $9 grand back, it's really worth it, because I can tell you, like, the two biggest things about litigation is how long is it going to take and how much is it going to cost, right? And everybody wants to nail me down to what's it going to cost me. And like, honestly, I don't know. On the traditional hourly method, I don't know. The other side could send over 500 pages of discovery requests that we're going to have to respond to. I just don't know if they're going to do that or not. And so with the subscription, even if they did that, your bill would still be $3 grand, right? So it gives you predictable pricing. It covers all of the attorney hours. It's really the way to go. I don't know if I would do it if I was owed 20 grand. And that's kind of up to the client, because it's,
I mean, I just had one that did it for 27.
Yes. And to some people it's worth it. To some people it's not, right? And so at the end of the day, you got to make it a business decision.
Right.
And I can tell you, a lot of our clients who are on our lien subscription, which is a flat monthly fee for all their lien services, have very few lawsuits.
Oh, very much.
Once you're on that subscription, people know that you need to be paid.
I think I have one of the clients we first tested it out with, the lien subscription, who's been on it for 7 years now since we started it. I don't think we've had a lawsuit from them in like the past 5 years.
No, I agree. And they're doing millions of dollars a year, like hundreds of millions of dollars a year.
Right. They're a big supplier, and they have no lawsuits come over. I don't even think we actually file liens for them anymore.
No, I know.
I think they kind of just get paid with the first notice. And I think maybe we filed 2 liens for them this year so far, but hardly any. And they send out a ton of notices.
No, and that's the thing, is that once you're consistent, the game is only so big where you're at. And
they see the pattern.
The people you're supplying to the same people who are working for the same GCs, they know if you're going to send the notices and file the liens. And so if they know that you're going to do that, you move to the top of the list to be paid, as opposed to those people who don't send the notices.
So what's the cost of doing nothing on a lien?
I mean, walking away from your money, right? You can do nothing, and the lien, you might get paid something 10 years down the road if they call and they're selling the property, but basically you're walking away from your money. And sometimes that's the best business decision. It just depends on the client and the situation. I'm not going to tell that every litigation and enforcing a lien is right for everybody, because it's not, right? And do realize, too, once you file suit on that lien, like if you're working directly for the owner could bring counterclaims. And after that, it's not just, okay, I want to walk away from my lawsuit.
That's the main thing. They'll start, and then they'll be like, oh, never mind. It's like, you can't just walk away anymore.
Yeah. And so if you're like working for an owner and you know that the process was rough, or, you might file the lien and then sit on it because you don't want to have that fight, right? Because once you start it, they can countersue you.
So let's talk about another topic that we get a lot is, can I just represent myself?
I mean, I guess you could. Well, first off, in Texas and in most states, at the level of court you need to do a lien foreclosure, you cannot represent yourself. The law requires.
JP court does not count.
Correct. In JP court, you can represent yourself all day long. But if you are a company and you're in district or county court, you can't represent yourself. Legally, you can't represent yourself. And if you're an individual, you could. But I've seen AI stuff. It's not, at least not yet. Not to the point it's going to replace attorneys for the most part. It may get there someday, but it's not there yet. You're going to do more. And here, if you do it wrong, it's not only would you lose your lien rights, right? You could end up paying the other side's attorney's fees. If you file a lien that's wrong and you prevent a sale, you could end up paying what they would have lost in that potential sale. So it's not only the risk of you losing your money, it's damages that you may cause to the other side wrongfully that you would be responsible for.
Let's talk about those mistakes. What can they do to make their own lien invalid? What kind of mistakes do we see all the time?
Oh, gosh. And here, okay, so having looked at the real property records, I can tell you 90% of liens are filed incorrectly at some point. And I'm talking about agencies that do it as well, right? They're very specific. Like, if you cannot prove that the letter was sent certified mail by the required date, your lien is invalid, right? If you did not send it to the right property owner, your lien is invalid, right? And so you can start with starting with the appraisal districts and doing it, the research that way to find the property owner. But a lot of the times, sometimes the property is sold and the CAD hasn't been updated and you don't know that. And so you've sent it to the wrong owner. Or what if you can't find the property on the CAD? That one happens all the time. You're just going to take a guess? It's because then you have to go to the real property. And so you have to go to real property records and find who the real owner is. So they're, what I tell my contractors, I wouldn't go out and build a house. That's not my job, right? This is not what I do, and I'm not good at it. It would definitely fall over. It's not something I do. The same thing is you shouldn't file your own lien because, like I said, not only could you risk losing your money, if you file an invalid lien, they can sue you to remove it, get their attorney's fees. I mean, we had it happen years ago when we actually filed a lien for a client, but he lied about the timelines.
Oh, yeah. I love when they do that.
So he lied. So he told us one time, and he signed the lien that said that time. But when the other side actually dove in, he was 2 months earlier. And so in that lien, because he lied, they removed his lien, and he had to pay the other side's attorney's fees of $100,000.
So there is a penalty for filing an invalid lien.
Correct. And there's not and here's the thing is when you go to file a lien, the clerk will accept whatever you file as long as it's got a legal description and a stamped affidavit. That is not vouching for the credibility of what you filed. Because they're just making sure that it has the form of the document has those two required things, a legal description and a notary, right? They're not doing all of the other things. One of the biggest things I see is there's got to be specific language in the notary block. It can't just be acknowledged. It's got to be subscribed, it's a legal technicality that has to be in there. Otherwise, your lien is completely invalid, right? And then sending the notice within 5 days after the lien is filed. Doesn't mean you have to wait to get the lien back from the clerk. You just got to send it out within 5 days. There's so many missteps. And don't be wrong, it took me the first 10 years of my practice to figure out how to do it right because the rules are so confusing. It's not something I would risk, especially, it's not something, even on a small amount, I wouldn't risk doing it on my own because of the consequences. And definitely in a large amount, you want to secure your money the right way.
So once we have a lien, when do we start negotiating?
When we start negotiating, as soon as we get the file, right? Even before we send out the first notices, we're making phone calls. We're trying to get somebody's attention. Because my whole point of you hiring us is not to file the lien. It's to get you paid, right? That's the end goal. I don't want to have to file a lien. I only get to the lien stage if I'm we send an intent, we make phone calls, we don't get anything back, right? So the negotiation starts off immediately of who can we contact to get the client paid, right? Because that's the important part.
I think our number one goal is to get them paid without filing. I mean, we will do the lien, we will foreclose, but we want to get you paid before you have to spend any more money.
Correct.
Is
Absolutely.
what our goal is. When does foreclosure make sense?
So if you're owed a large amount of money, right, it's definitely going to make sense. We have some clients that are owed hundreds of thousands of dollars, and for them, it definitely makes sense to not wait and move forward. Like I said, if the property is not going to sell, another case where you're definitely going to have to file suit is if you file the lien and someone bonded around it, right? So that happens, right? They'll get a stack of paperwork. It says bond and it references their lien. And so what happens with that is that the owner could still move forward with the sale or the refinancing without taking care of the lien. The lien is still there, but in order to enforce it, now the client would have to sue to enforce the lien against the bond company. So the money's there, right? The bond company is basically saying, hey, I have this pot of money. If you can prove that you're owed it in a lawsuit, I will pay it to you. So in that type of case, they're definitely going to have to move forward. If not, if they don't, it'll expire, the bond will be released, and then the client won't get paid.
So the bond company, they take over for the lien. What's next? Like just suing them, or what does that look like?
Yeah, so we will file suit to enforce lien against a bond company. Usually, we'll probably, in that case, we'll bring in, like if you have a breach of contract against a GC, we'll bring them in as well. And then, we'll prove that we have the valid lien, and we'll keep moving forward on the lawsuit. Usually, we'll bring the owner in as well under the attorney's fees claim, a prompt payment violation, which is interest, and trust fund claims, which is, hey, you got trust funds for a project and you didn't pay everybody. Just because when a bond is filed, it's for a certain amount. Say it's for $100,000 and your lien is for 50, and we go through all litigation, and you get your lien and you get $100,000 in fees on top of that. The bond company would only ever pay that $100,000, and so you need another party to go after to cover that difference.
So let's talk a little bit about our subscription.
Which kind, the lien or the litigation?
The litigation one. I think it's getting more and more traction now.
Okay.
Which I talked to one of our clients earlier this morning who was actually on the subscription. And he really liked the fact that he knew he was paying $3,000 a month. And it's broken out into two, which makes it a little bit more flexible for them. Like I said, his lien wasn't for much. It was for $24,000. But he was like, just the fact that I knew every month, okay, every 2 weeks I'm paying $1,500. It's not including cost. Cost is a little additional. But for him, it was kind of more of, I know this is what I got to put to the side to make sure that's paid for. He got paid his lien amount. We're still going after attorney's fees. However, he really enjoyed that part. I don't know if he has, and that's the Spanish side, has TCLF seen any good?
Yeah, I mean, I think, and so too, is where the subscription really works out is if a client got sued, right? Because then they really have no control over the costs. And if I can tell you it's going to cost you $3,000 or $5,000 a month.
Well, I think we're kind of giving them the option, right? You can go through the general or you can go through the subscription. And what I'm noticing also, I don't know if you've noticed, is they'll sign up on the general, and then when they see that bill starts getting kind of high, they'll be like, okay, never mind.
I think I want to go to the
I want to go this way.
And you can switch. You got to pay any outstanding balance first, but
they have that possibility to switch.
So.
All right.
All right. Thank you, guys. I hope this episode was informative on what do you do after you file a lien. Feel free to reach out to us if you have any questions. We're always here. Thanks.